Imagine you've submitted your land use application to your city. Maybe it's for a home addition, a conditional use permit, or a subdivision. As your application moves through the review process, what protections do you have? In Utah, the Land Use Development and Management Act, LUDMA, establishes specific procedural safeguards that ensure municipal land use decisions are made fairly, transparently, and consistently. It's called due process, and it's everyone's best friend. Think of due process as 3 pillars holding up a fair decision. Each pillar protects your rights at a different stage. Let's explore how these 3 pillars work together to ensure fairness. The first pillar is your right to notice. Under LUDMA, municipalities must inform you about every public hearing or meeting where your application might be considered. This isn't optional. Utah Code requires actual notice to applicants and proper public notice as prescribed by the law. So what does your notice have to include? The date, time, place, and purpose of the hearing or meeting. And why does this matter? Because you can't meaningfully defend your application or support it or understand what's being decided if you don't know when or where the decisions are being made. Notice ensures that you have a real opportunity to participate. The second pillar, fair process, protects the integrity of the decision-making process itself. LUDMA requires municipalities to avoid ethical violations that could compromise fairness. This includes financial conflicts of interest where decision makers have a personal stake in the outcome. It also prohibits ex parte communications. That's when applicants or opponents have private conversations with decision makers outside of public meetings. Every applicant deserves to have their project judged on its merits in an open forum, not behind closed doors. Utah Code establishes these due process protections to ensure everyone receives equal treatment under the law. The third pillar is perhaps the most important, your right to appeal. Even when you've received proper notice and a fair hearing, you still might disagree with the outcome. Under Utah Code, every municipality must establish an appeal authority. And effective 2026, most cities must designate a separate body as their appeal authority. The city council itself may no longer serve in that role for new appeals in these municipalities. This local appeal authority acts in a quasi-judicial capacity, meaning it functions like a specialized court. It provides an impartial review of whether the land use authority correctly interpreted and applied the municipality's own ordinances. The appeal authority reviews the evidence presented and determines if the decision was supported by substantial evidence on the record. If you're still not satisfied after the local appeal, you can appeal that interpretation and decision to district court. But here's the key. The courts are not likely to judge whether the local regulation is good or bad. Under state statute, courts presume that local land use decisions are valid unless proven to be arbitrary, capricious, or illegal. This sets a high bar. It protects a municipality's authority to make land use decisions while still providing meaningful judicial oversight. If a court does reverse a decision, it sends the matter back to the local government with instructions. The court doesn't make the land use decision itself. In 2026, state statute clarified what arbitrary and capricious means. A land use decision is arbitrary and capricious if it is not supported by substantial evidence in the record. A decision is illegal if it's based on an incorrect interpretation of a land use regulation, or it conflicts with state law, or is otherwise contrary to law. So what does this mean in practice? Due process under LUDMA creates a framework where property rights are respected and decisions are made transparently. For applicants, these protections mean your application will be evaluated openly and fairly with opportunities to be heard and challenge decisions you believe are incorrect. For municipalities, following these requirements reduces legal risk and builds public trust in the land use process. So whether you're a property owner, developer, or municipal official, understanding these due process protections is essential to navigating Utah's land use system fairly and effectively. This educational content was developed for the Land Use Academy of Utah. Funding was provided through the Land Use Training Fund, which is administered by the Office of Property Rights Ombudsman, utilizing a portion of the 1% surcharge on all building permits in the state of Utah. The role of this organization in administering funding is primarily administrative and should not be viewed as legal advice. Always consult your legal representative when addressing land use activities.